Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Hey, welcome back to the podcast. This week, my guest is Brian Meltzer, and he is a partner with Saul Ewing LLP. Welcome.
Hi, Gary. Thank you so much for having me. I'm really excited to be here.
So, Brian, what made you decide to get into the legal arena?
Yeah, so I was fortunate enough to go to a high school that had electives on law. And so from a pretty early age, I was taking constitutional law, criminal law classes, the stuff that you see in movies and TV shows that really makes you really want to get in there.
Right.
And I fell in love with it from there. And it carried me through college where I could take business law courses as part of my degree. And that's kind of all she wrote after that. I just knew I was sold.
Right. So kind of give us your journey. So you graduated college, went to law school, kind of what was after law school?
Sure. Yeah. So after law school, I started at a major law firm. I've always worked in Baltimore, but at the time I'd been living in DC. So I was doing that reverse commute for a little bit. And right before, like as I was in law school, I thought I wanted to be a criminal defense attorney. And so I had been doing some internships on that front. I did a clinic on that front too in law school, which is where you practice under somebody else's license. But I had also been working at law firms, and what I wanted out of this career was something that really put my brain to work, lawyer to lawyer. And I realized I was getting more of that on the business side more than the criminal side. And so I ended up putting all my eggs into that basket. And so in 2011, when I got hired for my first job, it was in the business law department of a law firm. And it's been great. I love it.
Right. So, we've had other guests on that have talked about the different documents and the importance of having them and things like that for business. So, I'm going to kind of skip past that and kind of get more into the, you do a lot with mergers and acquisitions and joint ventures and stuff like that. What are some of the things that, if I'm deciding that I'm going to go into a joint venture and I already have my own company and I want to go into a joint venture with, say, you,
Sure.
what are some of the things that we need to be thinking about when it comes to us getting together for a joint venture?
Yeah, that's a really good question. So a joint venture, to distinguish from just sort of a more general business, is a sort of a partnership where people come together for a more specific purpose. It could be investing in something, developing a product, maybe a side business that may be related to your main business, whatever it may be. And so the key is to understand what each party is bringing to the table, because that's really the value you're putting in there. And it's also the type of asset that you're going to want to protect and get back out, either when the partnership is done or when things maybe go south. I say when, I guess it's if, but us lawyers, we plan for the worst on the legal side. And so that's where all this paperwork really comes into play. So you'll have an operating agreement of some sort. You'll want to talk about how the governance works, who makes decisions. If one of you is going to be more of the day-to-day, what sort of things do you want to say on? Regardless of whether it's day-to-day or not, material items, fundamental decisions that really matter to the business. How can your asset that you're putting in there be used by the business? How can it not be used? And same for your partner in this venture. And ultimately, how do you know when it's finished? And how do you get out if you just can't see eye to eye on something, if it just needs to dissolve? And an operating agreement is really what's going to contain a lot of that in a joint venture or a joint venture agreement. It depends on how you structure it, but those are the sorts of things you really want to be mindful of. that's on top of what I imagine your listeners have already heard from some of your other guests about starting a business generally,
Mhm.
how to structure it, how to handle the tax bits. And I'm not a tax guy. I'll defer to you
Right.
and your brain on that. And all of that really matters at the end of the day because you're trying to protect what's yours.
No, so what happens if, again, you have your law practice, I have my accounting practice, and then, like I said, we decide to do this joint venture. Um, what happens if we don't do an operating agreement? What's the tell us the nightmare behind that?
Yeah, yeah. It sounds like you kind of already know. Um, so depending on what state you're in, the statutes at hand the law may tell you a little bit about what happens, but a lot of those laws actually assume you're going to have an operating agreement. Some states will require it, some don't. Maryland, for example, actually does not require
Right,
a written operating agreement. But anybody who kind of knows what they're doing will highly suggest that you get one, including myself.
right,
Um, for the specific reason that those laws will say, look to the operating agreement for these sorts of things, or unless your operating agreement says X, it's going to be this very simple, by the book process, which may just break things apart based on the ownership percentage. And that may be it. And that may be exactly what you don't want. And so, especially if you're coming in with something valuable that you plan to retain outside of this partnership, you want that entire thing coming back to you. And so, if you do not have an operating agreement, nightmare scenario is you may end up losing ownership of that asset you put in, because you didn't put any parameters around the restrictions on use, whether it's owned or licensed, and confidentiality was not memorialized, any of that. And that could be the most important thing to your main business or a separate venture that you might want to pursue later. Fighting over that can be expensive, to
right.
say the least. Litigators are not cheap.
Yeah, yeah. And I think that that's one of the things that's really important in talking about this is the operating agreement, because I know many times, as a CPA, I ask the client, it's like, okay, here, let me have the operating agreement, because I need to see that to see how profits are supposed to be split or capital is contributed and things like that. And many times they don't have them, or they may have gone to one of the online services and pulled one down, and literally that says, enter company name, and it literally says company name. And they obviously downloaded it to check a box, and that's it. Um, Talk about a little bit more about the importance of this operating agreement, because obviously if you and I are going into this joint venture together, you have certain skill sets that are being lent to our venture. I have certain skill sets or assets that I'm lending. Kind of what happens when we're doing this, and then suddenly you're incapacitated and you can't provide those services anymore.
Right, right. And that's actually a very real scenario that happens all the time, especially if you're dealing with two individuals as opposed to two companies.
Right,
Um, a solid operating agreement will contemplate that. It'll say if someone dies or is disabled, and it'll define what disability means.
right,
It'll say something to the effect of if you can't perform your duties for a certain amount of days consecutively, um, you are considered disabled under the agreement. And in that case, there could be a method to either buy you out, or shift control so that decisions that maybe require your say so maybe no longer do. Um, you also mentioned earlier the idea of capital contributions, which is also an overlooked thing that I think people need to really be mindful of, because, of course, everyone brings something in to launch this project, but it doesn't mean that's all you're going to need ever. You may need capital later, whether it's from you all or maybe even an additional party that comes in.
hmm,
Um, how do you protect your ownership interests, your percentage ownership? Because a lot of these voting thresholds, these approvals, may say it's a majority. There may be a majority without you after you bring in somebody else in, or if you choose not to contribute, for an additional slug of cash or an additional asset, you may be small enough in the pie where you don't get approval anymore. Operating agreements can cover all that in sometimes painstaking detail, but it's all for the the peace of mind that you know that it's been memorialized in writing. It's what everyone's agreed to. The less ambiguity, the better. Um, and I'll note sort of this idea of bringing things down from online service providers. There is a place for that sometimes.
Right.
I would say generally complexity is not there. I think cut corners cost a lot more to clean up than doing it right the first time.
Yeah, yeah, I agree with that wholeheartedly. I've seen it too many times that, you know, again, pay that extra money at the beginning so you're not paying it on the back end, because then it's the, if you're protecting yourself up front, then that way you're not exponentially having to pay, later on.
That's right.
So, flip the switch now to you're strictly attorney cap. We're not in this joint venture anymore.
Okay.
With an operating agreement, what are I guess what's your recommendation? Because I know from my standpoint, when I talk to potential clients, I tell them, hey, make a list of all the things that are important to you that you want to have in writing in this. Typically, we're talking about, compensation. We talk about, ownership and things like that. What do you recommend to people before they come see you to put one of these together? Because I think if you do a little bit of homework ahead of time, it's going to make your job easier. But I think it's going to maybe even, save the client a little bit of money, if they're somewhat prepared.
Yeah, and that's a good question. One thing that we've been assuming in this conversation so far is that we, in fact, have an operating agreement, relevant company, an LLC, a partnership equivalent.
Right.
That may not be the best structure for you. I think one of the first things you want to think about when you're going to form a business, with advice from a tax advisor, because a lot of these decisions are tax based, is what type of company, what type of entity do you want to form? What makes sense for this business, for your goals with the business? It could be an LLC, which is taxed as a partnership. It could be a corporation, and then there's various flavors of corporations. You could probably have a whole episode on a lot of these
Right.
questions we're going through, including this one. But that's the first thing you want to figure out. And a lawyer can help you walk through that. But so could an accountant, or another type of tax advisor. So I think that's one important thing. Another thing that's probably seems small, but is pretty important, especially if you want to build a really successful business, is what are you going to call your business?
Mhm.
Is that a name that you're allowed to even use?
Yeah.
We see a lot of businesses start with this great creative name, and then you find out there's either some behemoth that already has that name, or you find out that someone else just launched that like last week.
Right.
And there's easy ways to look into that. But branding and all of that, that's important too. And then also the capital intensity of what your business is going to require. Depending on the answer to that, you may want to bring in a number of people up front with more equity. You may need to borrow some money. Financing, it's very important to start your business and to figure out how to get off the ground. You don't have to have the perfect answer. You don't have to have every detail hammered out, but some sense, some roadmap of how you think you're going to end up bringing money into this company will also help inform how you end up structuring this operating agreement, structuring the ownership.
So you bring up a good point there when talking about, borrowing money or needing to finance. I think that one of the things that gets overlooked lots of times, in the operating agreement is, okay, and go back to our joint venture. It's like, okay, joint venture, I'm the one who's running the company. Am I allowed to create debt for our business? And if so, how much am I allowed to do without having approval and stuff like that? Is that something you usually put into an operating agreement, or is there another document that goes into?
Operating agreement. If there's an operating agreement, put it in there. If you don't have an operating agreement relevant company, if you have a corporation, a
Mhm.
stockholders agreement, or maybe a management services agreement. But definitely put that sort of thing in writing, because when you give somebody authority to run a business, if there isn't fencing around that, there's going to be at the best an argument when that person does something that you don't think they should be able to do.
Right.
And depending on what it is, the law may have given them that authority by the mere fact that you didn't stop them from doing it in an operating agreement or a stockholders agreement or something like that. So certainly when it comes to debt, it's definitely advisable to put something like that in writing, because with debt comes liens,
Mm-hmm.
and liens can create a lot of issues. I mean, let alone if they exist and you know about them, but especially the ones that you don't know exist and they get uncovered by an auditor or a potential buyer or a potential investor. You don't want that sort of surprise there. And the flavor of the lien may make it hard to bring in additional debt. Um, there could also be personal guarantees tied to
Right.
debt, which you wouldn't necessarily be subject to without knowing about it. But your business partner may have done it, and that can still create an obstacle for you going forward.
Yeah. I think to all of our listeners, kind of look at it that the operating agreement is, I'm going to say, the Bible of your business. What's in there is what's in there, and what you have to, the governing body or the governing document, if you want to call it, is really part of that. What are some other things that you see I'm going to say small business owners making mistakes besides not having, this operating agreement? Because I just always look at so many businesses don't have it, and it always comes back and bites them in the butt. So what are some other things that you see that hurt people?
Yeah. You could probably have a whole episode on that one too, but I think at a high level, one of the things we see most often, and honestly, even us lawyers are guilty of it sometimes, is signing things without reading them.
Yeah,
Um,
we all
I,
are. I mean, how many times have you gone, like, especially like on your phone or whatever, and you're like, all these disclaimers, there it is, boom, to finally sign it.
exactly. And, you know, there's a time and place that maybe it's worth skipping. I know there's so many terms and conditions. I think someone had done the math. It would take you like 30,000 years to actually read all of those online if you had ever done something like that. But I've represented some sellers. I can think of one in particular where, we're selling the company. The buyer is interested in digging into all the contracts, and lo and behold, there were personal guarantees on leases that the seller just didn't even realize what they were signing. They just signed a bunch
Right.
of personal guarantees. Um, Not deal killing, but certainly something we had to navigate, because that landlord was expecting a new guarantor on that lease. So we had to go convince that landlord that you're getting a really solid buyer. It's a totally different animal. You don't need this personal guarantee. Um, and landlords don't necessarily care about your deal moving fast, and so they'll kind of think about it and maybe go on vacation and come back a little bit, and hopefully they say yes. But better just read it. And if you're the sort of person that feels like you just kind of fall asleep after page two, I guarantee you there's an advisor out there that reads these so frequently they could do it relatively quickly,
Yeah.
and they'd be happy to help, us included.
Yeah.
Um, Another thing that I would say is, you know, even if you're going to read it and sign it, things are negotiable. In the worst case scenario, you try to negotiate and someone tells you it's not, but at least try, because there could definitely be areas where you can get a better deal than the one served up to you. Um, so again, not a fatal issue, but certainly something that you can help improve your business, especially at the early stage where every penny counts. Um, some of these provisions in these contracts talk about liability exposure. They talk about, you know, David having to reimburse Goliath for all of these damages. And a lot of the Goliaths expect you to just sign it. But they might actually have authority to negotiate it and just won't tell you.
Right.
So I think those are really good things to keep in mind, and easy to tackle, I think.
Yeah. I think, listeners, two big points that Brian has made today is, operating agreement or your bylaws or stockholder agreement, whatever it is, you got to have that. and due diligence. If you're buying a business, or getting into contract stuff, do your due diligence, pay somebody to do your due diligence if it's not your strong suit, because it's going to save you so much more, on the back end, when things do go wrong, and they will. At some point in time, something's going to go wrong, and you need to make sure that you're protected. You're right. We could take each one of these subjects and do a totally separate segment on it, for sure. The disputes and things like that come up, just to go back, that's something that you rely back on the operating agreement or shareholder agreement, whatever, depending on the entity structure of the document. But that's what you keep going back to, correct?
Yeah, if it's disputes within, that's right.
Right.
If you have a dispute with another owner, a fellow partner, it would normally be governed by something like that. As much as it can. There are some things where the law is just the law, but
Right.
you can cover a lot of ground in these operating agreements. With someone like an employee, that would be like an employment agreement, maybe a handbook, some policies they've agreed to. With a third party, like a customer or supplier, these contracts that I was talking about, these contracts that you should read and negotiate if you can. Get termination provisions if you can, right? The way you want to think about business transactions is, protecting what you're putting in, finding a way to get out, and protecting your risk in between.
Right.
Limited liability exposure. Everything that we do in contracts really can be boiled down to those three areas.
Great. All right, Brian, we covered a lot of stuff, really quickly here. What have I not asked you wish I had?
I think one thing that I'd like to talk about, if I can put the question in your mouth, is, what should someone do when they're thinking about buying or selling a business? So if I can assume you just asked that
Yeah, I
question.
just asked it.
Yeah, I think one of the things that I would say is there's some steps preliminarily that people overlook. Getting an NDA in place. It's a simple item.
All right, hang on. You just used an acronym.
I did. You're
Tell
right.
people what it means.
So a non-disclosure agreement or a confidentiality agreement, a contract that you put in place that says if we share information, the information I share with you is protected. You can't share it with anybody else. You can only use it for what we're talking about, this potential M&A transaction. M&A being mergers and acquisitions. I don't know if that counts.
Yes, yes, it does.
So a lot of people will get excited to enter into one of these discussions and will forget that they are just freely sharing information. And unless you have something that tells that party that they can't go ahead and share it further, they might be able to do that freely as well. And that could be really damaging if somebody's not acting with good intention. The next thing I would say that a lot of people not necessarily overlook entirely, but maybe don't take seriously or as seriously as maybe it should be taken, is the letter of intent or a term sheet, or what we call the LOI.
Right.
It's generally non-binding, and so it's not the sort of thing that is contract enforceable, but other than maybe a few provisions. But it sets a good tone for the deal. It sets expectations for what people are planning to do as you really memorialize this deal. And if you aren't seasoned or don't have an advisor that's really seasoned, you may end up getting cornered or outmaneuvered in a way that's really hard to backtrack. Sort of a four-letter word in these deals is the idea of retrading. So if people think everyone's on the same page from what's in this term sheet, and then you end up realizing that you didn't actually want that, but you just weren't really paying close enough attention, that other party may say, whoa, 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 whoa. Like I thought you understood. Like, I don't know that I really can do this deal if we're not going to do it that way. And I've seen deals screech to a halt over things that everyone thought, at least on the advisor side, was the way it was written in the term sheet. And then a party who had only engaged that advisor later said, oh, I actually thought it meant something else, and kind of put the brakes on and try and work it out.
Right.
And that could kill the deal depending on how significant it is. Now I could go into the entirety of the deal. I don't know if everyone wants to hear about that on this episode, but I think simple, upfront things like that can help make the entire process smoother, even if it's going to still be relatively complicated.
Yeah, I find lots of times, people try to get through this quickly because everybody's excited. But to me, that's where you make mistakes. And it's always better when forming or selling or purchasing to have the proper team of people with you that are going to help advise you. Yes, it's going to cost you a little bit of money to do it, but it's going to save you so much money on the back end by making sure that everything's in writing and it's clear and you understand it.
For sure. For sure. That's very well said. Yeah, having represented a lot of buyers and sellers, I can say when I'm on the buyer side, I can tell almost immediately if the other side is going to be outclassed. And
Yeah,
that's not meant to say that there aren't other great people out there. But if you don't hire someone who actually does that for their job, if you hire what we call sort of a Swiss Army knife,
yeah,
um, they're just not going to have seen as many instances and many varieties of these sorts of things. And they'll fight where they feel comfortable, and they'll likely roll over where they're not.
right, right. I think, we've had episodes when we've talked about, that, in the law arena, there are different specialties, and to make sure that you have someone who specializes in, mergers and acquisitions or purchases or contracts and stuff like that, if you're going to do this and not have that, necessarily trust in the state attorney or the criminal defense attorney type thing, because they're not versed in it. And like you said earlier, it's like, there are those people that do this every day, so they're able to get through things more efficiently than someone else would.
Absolutely, absolutely. Yeah, we see it a lot, and sometimes we benefit from it, sometimes we don't.
Right.
But at the end of the day, everyone's sanity will thank you if everyone's just in it with the experience they need.
Right, right. So Brian, if people like what they hear and they want to reach out to you, how can they reach you?
Sure. Yeah. So, like Gary said, I'm with Saul Ewing. We're a law firm with a footprint across the country, but I'm in the Baltimore office. I can be reached at 410-332-8613, or my email, brian.meltzer@saul.com. I'd be happy to speak with anybody that is interested in learning more, or maybe even working together.
Great, Brian. I really appreciate your time today and appreciate our talk.
Thanks. Likewise, Gary.
Great. Hey, this week my guest was Brian Meltzer, and he's a partner with Saul Ewing LLP. I'll see you guys next week.
49 faces looked to him in triumph. Over the last 12 months, they had each taken turns and promoted his business for a week at a time, driving over $987,342 in revenue. What if you had a network of 50 centers of influence who promoted your business every week for a year? Grab your copy of the #1 Amazon best-selling book, The Ultimate Guide to Growing Your Business with a Podcast, at 33% off the Amazon price by going to ultimatepodcastbook.com. Again, that website for 33% off the Amazon price is ultimatepodcastbook.com.